Hey guys, sorry for the delay. I was working. I had to finish something before I could take my lunch break. We've been having trouble all day because of that. What is it, AWS outage?
Yeah.
And so I'm having trouble connecting to the VPN. I can't get any work done. So I had to keep sitting there like trying and trying and trying. And then I had
Mhm.
to shove food in my mouth. So um, we do not have any kind of ruling on the continuance. I'm here though, so if something comes out like later in the afternoon and then the courthouse is open, I'll just go there myself. Um, Plus, it would get me out of this room where I've been sitting here trying to make the VPN work
Wow.
all day. Um,
You're
so
there.
we have a couple things to go. Yeah, we have a couple things to go over, which we probably won't read like word for word, just because I only have an hour break time. But I wanted to address some housekeeping issues first. Hold on. Okay.
Do I need to get the
I
vacuum out or?
No, you can do that later. It's fine.
Okay.
So I was previously referred to as the cult leader by this man, David Gingras, who I think he's still an attorney for some reason. Um, why am I in the dark? Because I'm in a poorly lit hotel room and I can't do anything about it.
Yeah.
But also because I'm apparently the queen of darkness.
Vibes.
So from now on, you will address me as Her Majesty, or I will not speak to you. Got it?
What is this?
No,
Is this a
this is
new
just
blog
David.
from our good friend
It is David's new
Boatless?
blog, yes, and he unfortunately doxed our friend by full name, home address, phone number, the works on that.
Who?
I don't want to say because
It wasn't me, was it?
no,
Oh,
Bruce, we know who you are. I mean,
everybody knows who I am.
no,
Come on
but
over. I mean, yeah,
yes, he's
the
decided that
weather's
I'm the
good.
queen of darkness now, and I guess he's like upset about my bar complaint. He says that I can't accept that he said bad things about me and that it hurt my widow feelings. The thing is, I don't really give a fuck how you talk about me on your blog. The fact that I'm not a lawyer and you are supposedly an internet free speech lawyer and you can't tell the difference between abuse of process in a legal document retaliating against a third party critic and using your blog to talk about your super special feelings is kind of ridiculous. I don't think that you should still have a law license if you can't tell the difference, but that'll be up to the bar, to decide. Obviously, I filed in both states, so that is up to them. And if they say, it doesn't amount to anything, then that's fine. I'll move on. But I think that this is getting a little ridiculous. He's now published multiple women's home addresses, phone numbers online in the last, I want to say, week, maybe 2 weeks. So it's pretty ridiculous. I know that he published my home address and my phone number onto his blog via a link where he like submitted that proof of service when I had filed a motion to strike his filings. And so he just like is reckless and does not give a shit about anything at this point.
Yeah, it's a complete lack of sensitivity.
Yeah.
And decorum.
Yeah, courtesy that we have always given him, despite our feelings towards him. So, it doesn't matter. I guess at this point, I'm just thinking like, if you would like for me to stop, talking about you in a way that makes you upset, stop being such a funny clown. Because when you write shit like this on your blog, I'm gonna turn it into cash because I know you hate it that much. So we'll see how that goes if you keep this up. You're doing great, hun. All right.
Yeah, I mean, there's a big difference between a court filing, a motion, or declaration, and just writing something on Twitter or a blog.
Exactly. It's really not that complex. The fact that he can't grasp that concept is a little concerning to me. But okay. Maybe he doesn't need to have a driver's license or a law license. We'll find out.
Portugal calls. He should have just dipped out to Portugal when I told him to.
Yeah, he probably should have. All right. Anyways,
listens to me.
This is I don't either, but I probably should.
You got a lot of work to do, Your Majesty.
Let's see. We got this expedited request for reconsideration. So remember, we found out at the end of last week that Laura was once again asking for a continuance. She filed this on Friday late in the afternoon, like right before everything closed, and we didn't really know what the condition was that she was talking about. So we're going to read this, and I'm going to tell you why it's fucking ridiculous. But first, Cat Lady, thank you for the $5. Fair. Once someone has deemed you royalty, it must be respected. Signed, Lord of the fucking spreadsheets. Fake Laura Owens, thank you for the $5. Poorly lit hotel rooms lead to twin pregnancies. Trust me, I know. Huh. I thought that was Airbnbs. Good to know. Thank you very much.
Just don't inhale.
Anyways, guys.
Bill Clinton joke.
Yeah. So, new objective medical evidence demonstrates that proceeding as scheduled would pose a life-threatening medical risk to petitioner. and deny her the ability to meaningfully participate in these proceedings. Do you guys want to know what changed? I'll give you a hint. It's nothing. Nothing changed. New medical evidence.
What is objective? Also, keep this in mind. We got to look for this. It says objective medical evidence.
Right. And bear in mind also there's no Exhibit A attached to this. So
there isn't?
I don't know what that means. Maybe it's just something that's not available to us, but I can't see why it wouldn't be given all the other exhibits have been. So
could that be something they would have redacted?
I have absolutely no idea. I think you have to get permission to file something under seal or redacted or like that, but I'm not positive. So maybe don't quote me on that. But anyways, attached as Exhibit A is a letter dated October 17th from Dr. Colleen Green, a medical provider that petitioner has been seeing since September 2024. Okay, first thing I want to point out is Dr. Colleen Green is, she's not an MD. She is a doctor of nursing practice. Okay. And she's also a psychiatric nurse practitioner. So let's bear that in mind when we are reading what's going on here. So Dr. Green states that participating in a hearing next week would be life-threatening for her.
Participating, not just attending in person or attending on Zoom.
Because of the combined psychiatric and physical decline, this new evidence, unavailable when the court previously ruled like 4 days ago, directly rebuts any assumption that petitioner is capable of safely participating in a contested proceeding at this time.
How is this objective evidence? I mean, this isn't something like if you, you know, if you measure the width of a doorway today and you measure it tomorrow and nobody's done any work on the doorway, it's the same width.
Right.
That's objective evidence.
Your Honor, I have the tumor in the shape of a fiber logo.
What does this even mean? A doctor's note? That's not, I mean, it might be objective that there exists a doctor's note, but that's not evidence of anything you can conclude.
Let me tell you why I think this is fake. I think it's fake. Okay. Because a psychiatric nurse practitioner is not going to write that she has a potentially fatal GI condition and not send her to the emergency room right away. They're not going to be like, well, I guess you should go to the doctor on October 22nd. Not before, not after. And then also a psychiatric nurse practitioner who says that this person's life is threatened based on psychiatric factors is putting their license severely at risk if they don't immediately, sign a certificate to get that person involuntarily committed for a 72-hour hold.
Yeah, what does that mean? Like, what is the actual threat to life of attending something in person or attending something over Zoom?
Unclear.
Or Teams?
Yeah.
Like, what would the threat to life be?
I
don't.
This is a different world that she lives in, so I'm not really positive. I guess we're going to find out some more. In addition, petitioners, other treating medical providers, you have not apparently provided any notes from, I should add, have diagnosed extreme anorexia. We know about this, bud. We've been over this, babe. It's not an excuse to delay your hearing. The judge said no. And she has had gastrointestinal bleeding. We knew that too. Her most recent lab results show hemoglobin and hematocrit levels approaching transfusion range, corroborating the seriousness of her condition. Okay, so go get a transfusion or take some iron. That's what they're going to do for you. You don't have to wait until October 22nd to do that. In fact, if it's that bad, they are not going to have you wait to do that. They would do it in the ER if it was that bad.
What does that mean? Does this just mean low iron levels? Like you should be on an iron supplement?
It means you have I don't know it's not iron. I'm trying to remember. It's like something in the blood that indicates you need a blood transfusion. Like you have really low. I wish I could explain better, but I'm not like a medical, you know what I mean? I just do the psych. So, but I do have to look at those levels a lot because I have to explain to insurance companies why they need to pay for certain GI procedures. And so I know what a low level is. So if I looked at her levels, I could tell you how bad it actually is and how emergent it actually is. But she doesn't seem to include that here. So I'm kind of when it comes to the actual medical procedures and stuff like that, I'm kind of I have bare bones knowledge in that. I know I can see something. I know that's a really low hemoglobin or that's a really high white count or something like that. But I can't really tell you exactly what it is.
Why would hemoglobin and hematocrit levels be low? Assuming low is what this means when it says approaching transfusion range. I'm assuming that means low.
Lots of people need transfusions and go about their daily life still. Correct.
What is the root cause of a low reading for these two things?
Yeah.
That's my first question. My second one is,
A chronic condition.
where is the independent medical provider's diagnosis sent from the provider to the court or to Omar, I suppose, in this case, with the diagnosis of this extreme anorexia and gastrointestinal bleeding? Have those records been sent as independently verifiable proof of
Well,
these
that's going to be a
claims?
fat no.
Because right now, to me, this is a claim.
Correct.
Note how the language here is in the past tense. Have diagnosed.
Mhm.
She has had.
Yeah.
Past tense. Why can't the providers send those documents and information to the court and or Omar?
There's she
Prove
gave them
these
like
claims.
she gave them no notice, first of all. So like, what are they supposed to do? Get all that today? It's not gonna happen.
And if you scroll back up a little bit, just a little bit.
Yeah.
Where is it here? Okay. So she's been seeing this person since September 2024. It's nearly the end of October.
Right.
So why is this happening now, minutes before the court hearing?
Yeah.
Instead of September.
Mm-hmm.
Strange.
When did she find out she had an appointment on October 22nd? Apparently, like right now. So, all right. Following multiple episodes of vomiting blood, petitioners. That's what I thought it was going to be, because that's common with like anorexia and stuff like that. Or no, not even anorexia.
You actually called that, I think, in one of our last live streams.
Yeah, because we were all people were saying like anal bleeding. I was like, I don't think it's anal bleeding, guys.
Things can go up and things can go down, and sometimes things go up instead of down.
Yeah. Right.
To be discreet about it.
Petitioners treating physicians advised that urgent GI testing and specialist evaluation were medically necessary. And what date did they say that on?
Mm-hmm.
Petitioner was referred for GI consultation scheduled for October 22nd, which was the earliest available date for the required procedures. So if you're getting a consult with GI, you're not undergoing procedures. You're getting a consult. The overlap with the hearing date is entirely unavoidable. Honey, no.
I think she means testing procedure.
I don't know. Still, a consult's a consult. You don't go in there like with orders for testing or anything like that. You just get a consult.
You might have an order for testing following the consult.
Afterwards,
yes. You're saying.
Yeah.
Like,
but if they didn't have availability to do that, like on that date, they still don't have availability to do that on that date. Like if you show up for a consult on the 22nd, they don't have any room for you. Mm-hmm. You still have to wait. So you can probably go somewhere between, that date and when they have availability for the procedure, and still have a consult after that date, but before the available date for procedures.
Well, even if you can go get like a blood draw after a consult, you still don't know at the time you get scheduled a consult when that will be. Yeah. You still have to wait and find out. It's very strange. So the writing here is very vague. And you're right that it's missing important details. What she's saying here isn't as important as what she's not saying, which is when, physicians. Okay, who are these physicians? They advise something. When did they advise it? You were referred. When were you referred? By who were you referred? Who were you referred to? There's just this huge lack of information here.
All right. Then it's like very much the same as what she said before, so I don't really feel like it changed anything. She's maybe giving more detail, like I was vomiting blood, instead of just saying GI bleeding, but it hasn't changed.
And it's only to include sort of the sensational detail, right? Not any of the mundane details that you would see in sort of a normal explanation of what's going on.
All right. So what did we get to? The overlap with the hearing date is entirely unavoidable. That's, almost certainly untrue. Okay. As the appointment was made immediately upon referral for a very serious condition. Well, when you get referred, they make you an appointment. It's pretty standard. Postponing this appointment could delay essential diagnostics for several weeks. Again, no.
It could, but how do you know it would?
It's not going to happen.
That's
and significantly increase the risk of further bleeding, worsening anemia, and medical destabilization. okay, if you have a chronic condition and you haven't done anything to treat your chronic condition, sure, that's certainly true, but it's not an emergent acute issue. This is something that's been going on. You have neglected to take care of yourself in that regard. And now you want to point out, like, this is a convenient time for me to really want to take care of this issue. That shouldn't fly. Will it? Maybe. I don't know, but it shouldn't. So she again asked to rule on the papers, even though the judge said no to that. Today is October 17th, and this hearing is scheduled for October 21 to 22. The intervening weekend leaves no business days to notice or calendar an ex parte application. Accordingly, there is no practical opportunity for a hearing or oral argument before the scheduled dates, and you made sure of that. Given the medical urgency and the newly submitted documentation, petitioner respectfully requests that the court rule on this request in the papers pursuant to its authority. Okay.
I mean, isn't this the notice? I'm confused. What's she saying? There's no business days to do what?
To do like a hearing or oral argument to like move the dates. Because there was a week in between, which is frankly almost certainly why she filed this on a Friday afternoon right before the close of the court. Because she didn't want for there to be time. The judge wouldn't see this until today. So, given the medical urgency and the newly submitted documentation, which we can't see, by the way, petitioner respectfully requests that the court rule on this request in the papers. These provisions authorize the court to determine matters without oral argument when good cause and exceptional circumstances exist. No, that's not what's going on here. As proceeding next week would place petitioner at a documented life-threatening medical risk. And I want it, once again, I just want to point out that a psychiatric nurse practitioner who is the only person who appears to have actually written anything on her behalf would not write a letter saying that somebody is at a life-threatening medical risk without having them hospitalized involuntarily if they had to, because that would risk their license and their livelihood, and no self-respecting professional is going to do that. So I don't know if that letter's real or not.
That seems very strange. If you scroll up, I'm still hung up on this paragraph above. Okay, that one. Okay, so I understand the final sentence, right? She's saying there's no practical opportunity for a hearing. Okay, but the prior sentence says the intervening weekend leaves no business days to notice or calendar an ex parte application. Application for what?
I don't know. It's got to have something to do with postponing the hearing. I don't want to lie to you, though. I have no idea what that means.
Also, doesn't it leave Monday? Like, I feel like this is wrong. This middle sentence is wrong. I understand the third sentence. I feel like this middle sentence is just factually wrong.
Yeah. Right.
Unless
to have a hearing like Omar did? Yeah. Okay. Well, yeah, that's true. Toadette, thank you for the 11. We appreciate you, Your Majesty. Lauren and Bruce, thank you very much. Cat Lady, thank you for the $10. Wait, is the psych NP supposedly write the medical note she's quoting? Yes. Because psych would not diagnose, treat, or monitor physical health. Where's the note from whoever is diagnosing the GI? Well, she didn't include that.
Exactly. It's all vague, right?
That's like a silly little detail. Who needs that?
Yeah.
This request is made in good faith and not for purposes of delay. Yeah, and I'm pregnant with twins. Petitioner seeks only sufficient time to stabilize medically and safely participate once her treating professionals determine that doing so will not pose a life-threatening risk. No. So she's asking they vacate the order denying the continuance, they grant the continuance of the hearing, and then they order any further relief. So if this is granted, what she's obviously going to do is like use that time to try to find an attorney, because she can't actually step up to the plate and represent herself as the judge told her she would need to. She said, you need to get an attorney soon or you're going to be representing yourself. So
very suspicious.
Yeah. Especially when you think about her history. So yeah, we'll see though. We'll see. Anyways, this is her declaration in support of that. I don't know if it really says anything too substantial. We'll see. So she's talking about what the doctor says. The doctor, by the way, who is not like a medical doctor. I just want to point that out again. Is a doctor of nursing practice, which not to knock DNPs, right? But this is not an MD. I just want to point that out.
What would be the job function of that person, legitimately?
People who have DNPs, in my experience, have been like managers of nursing units and stuff like that. Yeah, I don't really know if there's any more functionality than that to a DNP because I don't look into nursing too much other than psych stuff. So obviously not a DNP cannot diagnose outside of their scope. The judge isn't stupid. Yeah. Right. But I don't know really what a DNP does other than, I've seen a lot of managers have it and a lot of head nurses and charge nurses and stuff like that will have it. Yeah. So like I said, I don't want to knock that. It's not like they didn't do like the work and like go through school to have, like extra
I
skills.
may have a relative with that.
Yeah. It's not like a DNP is anything to snuff at. I'm just saying it's not a medical doctor. And it's not somebody who's going to just diagnose random medical conditions when they're a psych nurse, I had the worst treatment from a psych nurse practitioner. I mean, it's pretty hit or miss. I've worked with a lot of them. I have some of the best providers I ever met who worked really well with their patients were nurse practitioners, and some of the worst were nurse practitioners. So it's really hit or miss.
And the first P is specifically for psychiatric?
Yeah.
Okay.
Okay. I think it's like PMHNP or something. I can't remember exactly the abbreviation. Anyways, since the court's prior denial, I've obtained new medical evidence attached as Exhibit A, which we don't have, from Dr. Colleen Green, a medical provider I've been seeing since September. We know this already. Dr. Green states that participating in a hearing next week would be life-threatening for her because of the combined psychiatric and physical decline. Again, a psychiatric provider with a license would never write something like this and use the words life-threatening unless they were going to immediately hospitalize them. Also,
it's a very, very short quote.
Yep.
That's put in quotation marks. So it makes you wonder what the full context of that sentence is, if it indeed is legitimate. What we don't know.
Hey, Rachel. I hope you're feeling better, man. Guys, Rachel's show won the daytime Emmy. That was pretty cool. I don't know if
Congrats.
You saw that. Yeah.
Very awesome. Rachel.
She's been sick though. I'm sorry.
Oh, feel better soon.
Yeah, man. Anyways, where were we here? I lost my place.
New evidence unavailable when the court previously ruled.
Okay.
So there's another claim because we don't know when this letter was received.
No.
Relative to the court rulings.
This letter that would absolutely never be written by a licensed psych professional.
So we're missing a lot of information.
My licensed psychiatric nurse says that I'm going to have a GI explosion if you don't postpone my court date.
This is very strange. You know what it reminds me of? It reminds me of all that stuff where the what was it? The Banner Health patient portal.
Yeah, I mean that pretty much says it all, doesn't it?
Neurology department was providing the proof of pregnancy, right?
Well, jeez, we gotta move this along, dude. I gotta go back to work in like 35 minutes.
Okay.
Stop talking.
Damn it.
Okay. Oh shit! I hate when this happens. My screen's going all crazy.
What are you doing?
Well, now I'm delaying.
You spit on the camera?
I don't spit on things. Hang on. There we go.
That would be rude.
Yeah. Okay. Anyways. In addition to Dr. Green's findings, my other treating medical providers have diagnosed extreme anorexia following a 50-pound weight loss. That's shocking to no one. Accompanied by GI bleeding. Again, keep talking about your GI bleeding. It's still been happening for months. I think you're going to be fine for another 2 days. If that's even actually happening. Following multiple episodes of vomiting blood. So we kind of went through that in the last one. I'm not going to talk with that. The overlap with the hearing date is entirely unavoidable. That is almost certainly untrue. The appointment was made immediately upon referral for a very serious condition. That's like me saying I left my doctor's appointment and they had me immediately schedule the next one at the scheduling desk while I was leaving. Like, this is not an emergent thing. Postponing this appointment could delay essential diagnostics for several weeks and significantly increase the risk of further bleeding, worsening anemia, and medical destabilization. Go to the ER. Cry about it. I don't care.
Also, I don't believe that uses the word could. We don't know when the next appointment is. There's a difference between could and is. And she's glossing over that here, which is very...
Where are all these other medical providers? They're under the clothes in the casita.
Yeah, that's a big red flag, is that there's no names or information here about any other medical providers, let alone what she should really be doing is having those medical providers send the court or send to Omar.
I don't understand.
All the information.
Does Dr. Medchill not enter the equation here? Like, what's going on here? There's at least 2 doctors that have seen signs of life, so maybe we should just give her what she wants,
I think if the 9,000 women that Dr. Medchill
oh God, there's no way that
watched
number
while
is
they
real.
had babies or whatever, if the babies came out of their mouth, maybe he would be able to help us here, since she's vomiting blood. But since they're not, maybe Dr. Medchill's not the right person for this case.
Sorry, you just put that.
I'm just looking out for my boy Medchill,
Don't. Oh God. Well, I mean, you guys look the same, so. Both retirement.
That's my future in 30 years. Yeah. Oh boy.
I dig it. I'm into it. All right. This request is made in good faith. Well, that's not true. I'm asking only for sufficient time to stabilize medically and participate safely once my treating professionals determine that doing so will no longer pose a life-threatening risk. You know how long that usually takes from a psych provider? About 72 hours. You might want to check into that, but after the 22nd.
Yeah, I mean, so Lauren, we're not talking about a medical life-threatening risk here. We're talking about a psychological life-threatening risk.
We're talking about a medical life-threatening risk, which is apparently being supported by a psychiatric nurse who, by the way, you have to establish care with this person per her own website in person. So Laura Owens, the woman who refused to go to the emergency room when having her pretend miscarriage and instead texted a hotline, supposedly drove all the way down to Tucson. I'm to believe she drove all the way to Tucson for a doctor's appointment. And now this person is saying her stomach is going to explode if she doesn't go to the doctor again on the 22nd. Not the 20th,
not that far,
the 23rd. What?
Tucson's not that far, is it?
It's a couple hours, hour and a half. I just did that drive a couple months ago.
It's not bad.
Yeah.
But my question is, like, my point is, if I injure myself with a chainsaw, I have a medical life-threatening risk.
Can we talk more about how that happened?
It's just an example, okay?
Yeah.
Fingers crossed. But if I injure myself
fingers
with a chainsaw,
that happened for sure, but how did it happen?
That's a medical life-threatening risk as opposed to a psychological oriented life-threatening risk.
Bruce, if you injure yourself with a chainsaw, I think there's a little bit of psych at play. I don't know.
Maybe I just didn't read the warning labels on the ladder. I don't know. But anyway, forget about that.
No,
does that make sense? Is that correct?
Sorry, I wasn't actually listening. I'm sorry.
Okay. When she says,
I was too busy thinking about you chainsawing yourself.
When she says that attending the case poses a life-threatening risk,
correct?
I'm trying to understand that's a psychologically oriented life-threatening risk as opposed to a purely physical life-threatening risk.
That's why it doesn't make sense. It makes no sense. Like I said, no self-respecting provider would have written this note. Just based on the little bit that we can see here.
So the remedy for a psychologically oriented life-threatening risk, it would be what you're saying, right? Like a 72-hour psychiatric hold,
right?
An evaluation.
So like
and the remedy,
send the cops
just to finish that,
the
remedy for a physically only oriented, like injuring yourself with a chainsaw, would be you go to an emergency room, you go to urgent care, and then you have documentation of that. So these are two different remedies.
Well, you would also be most likely, if you injured yourself with a chainsaw, immediately hospitalized. So not just an ER note, but
maybe it's not that. Maybe it's, I
mean, I guess that would cause GI bleeding if we're going to get really into the weeds here.
I don't know. Depends on where I poke myself with my chainsaw. But anyway, the remedy here has not been sought, is the point I'm trying to get to. The correct remedy, as opposed to like, she should have just gone to the ER. No, maybe not. She should have had a psych eval and hold.
That lady needs so many psych evals, but
it's
not going to happen. Hey, Rachel, why are you shouting?
Nobody knows what we're talking about.
I don't know what she's talking about. I think she might still have a fever. It's fine. She's special.
More cowbell. Anyway,
let's move on to this last one because I'm going to run through this in like 20 minutes.
Mm-hmm.
What time is it? Actually,
2:07.
12:07.
12:07 for you.
Yeah. I'm sorry. Let me see what Megan's doing. Okay. Don't mind me. I'm just texting. Okay, so this is like she's trying to exclude some evidence here of Mike's, and by some I mean all of it. Pretty much all of it.
Okay, this was going to be exciting. All right.
This is the thing I couldn't pronounce forever. So
just say lemonade then, because everybody will know what you mean.
Right. So she obviously wants to exclude Greg Woodnick, which is, I'm not shocked. But hasn't she done enough to Greg Woodnick after she tried to tell the judge that he conspired to have her assaulted or something?
Disturbing.
Okay. Mr. Woodnick is not as a percipient witness, but as an expert to give personal opinions about petitioner's credibility and mental state, topics that are inadmissible under California evidence law. Don't you keep trying to admit it? Lady, can you answer the question? Sorry, I know you're watching. You might as well just put it in the chat.
I mean, she can make these arguments. Will they work? We will see.
I don't fucking know, but this seems a little ridiculous to me. Lack of personal knowledge and relevance. That's cute. Let's see. Unrelated proceedings have no bearing on whether petitioner continues to harbor a reasonable apprehension of future abuse from respondent as required by Family Code 634A. Okay, so every time I kind of skimmed over this. So every time I see her talking about, the reasonable apprehension of future abuse and how some of this stuff doesn't apply, I'm like, have you seen your own witness list? Because
yeah, I think
you might want to stay away from those arguments if you.
To me, the thing that directly refutes this argument is her witness for the June 10th 911 call debacle is her former lawyer, David S. Gingras, Esquire. The opposing counsel in that case, who was a direct witness to those events himself, is Greg Woodnick, Esquire. Sure. So if you file a motion in limine against Greg Woodnick, that should also be amenable to exclude Gingras, wouldn't it?
No, David's very special. It doesn't count.
So to me, this thing just falls apart because the argument you're making to call your witness Gingras is the exact same argument you should be using to call Woodnick. And in which case, this motion in limine falls apart.
Okay. Well, I mean, I would also just like to point out that if David is not excluded and he does have to testify, then he would have to take a day off from writing about me in that diary he calls a law firm website. So
well, I don't think anybody's trying to exclude Gingras from testifying, are they?
No, somebody probably should on her side, but no, I don't think anyone else is. No, that'd be like the best thing ever.
If I'm a one-way ticket to Iceland.
It's not far enough away. You'd be crying in the bathroom.
She's good at finding inexpensive tickets to Iceland.
Yeah, I mean, we'll give her that. I guess she has some talent. That's a joke. All right. Bias, hostility, and retaliatory motive. Honey. Okay. The record establishes an extraordinary conflict of interest. According to the court-generated email chain dated August 1st, petitioner reported to the Maricopa County Superior Court that she had been assaulted. You're actually bringing this up. Oh shit! This is a real dumbass.
This is a real circular argument. This guy must be angry at me for the horrible things I did to him.
This is delusional. Why would you bring this up? Why would you bring this up? Okay.
This is kind of wild. Like, hey, by the way, court in California, I previously was involved in ex parte communication, which was not permitted. By the way, I thought you should know.
That I say a bunch of crazy shit about everyone, including this guy's attorney. Yeah. Okay. Well, I'm actually kind of really surprised to see this here. I thought that she at least had the wherewithal at this point to not include something like that, but I've clearly have been wrong before. So
I think that, and then this is hilarious because she goes on to explain Greg Woodnick's public statements, which are basically arguments, right? Like legal arguments, PR arguments, effectively. And she says this is sustained hostility, when all he did was reiterate what he thinks she's done, which actually the court effectively ruled was true.
Yeah.
Right?
Sorry, Rachel's smarter than us. I'm reading her comments.
Reasonable apprehension of future abuse must be reasonable and credible. So credibility is at issue, and hence all of her lies under oath. Yeah. So Greg Woodnick is basically saying, look, we have a ruling from Judge Mata in the case I was involved in, I was a witness in, and when I say I think she's someone who fabricates abuse allegations and suffers from unreasonable fear, these statements are effectively held up by the June 10th, by the Owens v. Eckerd paternity rulings and appeal rulings. Because Mata wanted to overturn the TRO or whatever it was called, OOP, against Clayton that Laura had. But she said, functionally, my court, family court, is not the place where that can be done. So I can't do it, or I would. So this is the direct refutation of her argument here.
Oh my God. Hey, Jack, what's up? Is she too ill to provide citations? Yes. Always. Okay. So I still can't believe she put this in here, but the court's judicial assistant forwarded the message to Mr. Woodnick and reminded petitioner that ex parte communication was not permitted.
Naughty, naughty.
Jesus. From that moment, Mr. Woodnick became aware that petitioner had personally accused him of serious misconduct.
Yes, he did. Because you did.
That works. Yeah.
Shocking. The tautology is strong.
There was a pending FBI investigation. Sounds like something I would say to a patient to get them to take their meds.
We still don't know if there actually was a pending FBI investigation or not.
No.
There's no evidence that there was.
No. How many times do you think she's called the FBI?
At least twice.
I'd say at least 12 times, but all right. They probably have a file on her.
Woodnick,
I don't think it's what she thinks it is. All right. Since that disclosure, his actions toward petitioner have reflected sustained hostility. Well, I mean, I don't know if that's true, first of all, but second, I would probably have some sustained hostility if you falsely accuse me of some sort of rape plot. So
it's an opinion, right? There's no science test I can do for determining if Greg Woodnick has sustained hostility. It's just an opinion.
Over under on Laura calling FBI 6, 7. Okay.
6, 7. Is that what that?
Okay. Has described petitioner publicly as someone who fabricates abuse allegations and suffers from unreasonable fear. Okay. While representing a different adverse party.
Oh, the hostility.
Yeah, he issued
my pearls. I'm clutching them.
Don't touch your pearls, man. It's fine.
Clutching them.
Save that for later. It's going to get worse. Press release repeating those phrases and asserting that petitioner had falsified evidence. Statements made months before any evidentiary hearing or ruling in the Arizona matter. So you in your deposition admitted to falsifying evidence. Are you okay?
Mm-hmm.
Like what were you smoking when you wrote this? Petitioner later filed a state bar of Arizona complaint. I just wonder if that he like David now has a wiki page for his bar complaints. But okay, that's neither here nor there.
She doesn't like the one statement that Woodnick put out versus Gingris's years of Twitter posts and blogs and YouTube videos and Home Depot costumes and shiny yellow shoes. Give me a break.
Did you say shiny yellow shoes?
Yeah.
What did I miss?
Gingras has shiny yellow shoes.
Ew.
Come on, Your Majesty, get it together. Catch up.
Your Majesty is right. Okay. Having been personally accused of abuse and professionally reported for misconduct, Mr. Woodnick now seeks to testify as an expert that petitioner fabricates abuse allegations. That sequence creates a textbook retaliatory motive under Evidence Code 780F. So, textbook retaliatory motive. Kind of, when I see that, I think of what she said about her former friend, who was also named as a witness, who she's seeking to exclude here, by the way, but also has named her on her witness list, which I don't know if that's normally a thing, but it sounded a little weird to me. That
was a gangster move for sure. Also, the thing is, here's the thing. She made a claim about Woodnick and Greg Gillespie in an ex parte letter to a judge, which was made known to the litigants and everybody, and nothing came of it, right? So what exactly are they retaliating against? There was no, there was nothing that she did to Greg Woodnick, right? That had an effect. So there can't be any retaliation.
I mean, it makes sense when you say it like that.
It's not like she.
I'm just reading the page.
It's not like she accused Woodnick of a crime and he was arrested and suffered consequences, and now he's retaliating. There's nothing to retaliate against. So this argument falls on the floor as well.
Yeah. I mean, this is pretty bad in my opinion, but we're gonna skim ahead here. Improper expert and character testimony. Fuck off. Mischaracterization of Arizona proceedings. No. Unfair prejudice and confusion. Permitting Mr. Woodnick to testify would transform this renewal hearing into a collateral trial on Arizona disputes, disciplinary filings, and press publications. The minimal probative value of such testimony is far outweighed by the danger of unfair prejudice, confusion of issues, and harassment of the protected party. Fuck off. No.
Well, she's the one who filed this motion to renew.
Right. Yeah. Right.
Based on actions that occurred in Arizona.
Yeah.
So this is just a response to that. If she didn't want to talk about things that happened in Arizona, she shouldn't have brought them up.
Yeah. This whole thing is just really annoying. I'm going to skim ahead to the next person because I feel like we've heard enough of this.
Right.
And I have to keep it moving because I got work. So, Section 2 to exclude a witness. Number 4, John Berryhill, the digital forensics expert, the guy who validated the text messages from Mike's computer. Respondent seeks to call a privately retained digital forensics witness, Mr. Berryhill, to introduce a 2024 report and text messages from 2016 to 17. Materials never filed in this case and unrelated to the records supporting either the 2018 restraining order or its 2020 renewal. Okay.
So?
Isn't this more to do with her credibility, though? So what's the point?
There's nothing that says you can't talk about evidence related to the time period 2020 to 2025.
Well, she'd be a little fucked.
Renewal is
if that was the case.
This renewal is covering events between 2020 and 2025. So if there was forensic evidence uncovered after 2020, of course it's not going to be from 2016 to 2018. By definition, again, she's spitting out tautology. Tautology is just saying, like, blue is blue. Like, yeah, of course it is. Like, that's the law of identity. She's just saying something that's self-evident, but it's not an argument.
Mm-hmm.
It's not a compelling argument.
Sure. All right, I'm gonna skip through some of this stuff. Of course, this is like posted online, so if anybody really wants to read all that, you can. I might
do a video down in my wood paneled room where I read through this whole document.
In the wood paneled room, well, count me in. I'm going to listen to
paneling.
that.
Yeah, ensconced in wood paneling. That's how I like to live my life.
Well, I mean, if you're going to record it in the room you're in right now, I'm just not going to listen. So.
I know. Well, it's too echoey in here.
You sound fine.
I got to work on it. Switch to a dynamic mic instead of this condenser mic. That'll help. Whatever
that means. So, of course, she wants to exclude Greg. Respondent proposes to call Mr. Gillespie to repeat discredited allegations from Arizona litigation. What? That were resolved entirely on procedural grounds and never adjudicated as true. I don't know if that's exactly how that went, but no court has ever found that petitioner falsified a pregnancy. Well, I don't. Okay.
Even in the Clayton Eckerd case?
Yeah, no court has ever found petitioner falsified a pregnancy.
I don't know if that's accurate.
Submitted a forged ultrasound. Lady, you said that you did that in your deposition.
I think maybe she just means no court ever found she did that to Gillespie specifically. But the way she failed to write it with that specificity in the language she used here.
I'm going to predict she says the same thing in Clayton's paragraph.
We'll see.
And we will. Okay. Such testimony would be irrelevant, misleading, and unduly prejudicial. Irrelevance to renewal, whatever. No adjudicated findings of fabrication or fraud, whatever.
She wants to eliminate Clayton as well?
Yeah.
Oh, boy.
Like almost everything, I think. Protective orders remain in effect. Okay, the judge already told you that doesn't matter. You can be in the courtroom where there are, like multiple security guards and shit like that. Like, you're going to be fine. People have to every day go to court like with people who have orders against them or they have orders against the other person. You're not that fucking special. All right, just get over it. Especially because you faked the whole thing. So I don't really have any sympathy for that. Maybe if I thought that she was ever, if I thought that she was ever actually harassed or abused, I would.
I guess we're in a hurry, but I have comments about that last paragraph, but I can do that on my own, I guess, if we're in a hurry.
Sorry, one sec. I didn't even hear you. I'm really sorry.
Oh boy.
All right. So Laz is going to be the same as Clayton's.
She doesn't say why testimony would mislead the jury or cause undue prejudice.
I don't know, man. Let's see.
She just says it would do that.
Yeah.
But why?
For fun. I don't know. So she wants to, of course, exclude the investigator from Maricopa County. She's a law enforcement investigator from Arizona who seeks to testify about an ongoing criminal case. I'm sorry, you couldn't pay me to write
this. Mean the subpoena served on Mr. Bowe is procedurally void.
Was that a dude? I thought it was a lady. My bad. Doesn't matter.
What does that mean?
It means I thought Terry Bowe was a chick.
The subpoena form contains no signature or date of issuance on the attorney's signature line. A subpoena must be signed by the clerk of court or by an attorney as an officer of the court. An unsigned subpoena is a nullity. Creates no duty to appear or produce documents. Well, I mean, that might be an argument why Terry Bowe wouldn't show up if they didn't want to.
Right.
It's not an argument for putting them in a motion in limine, though.
You cannot show up because this.
I mean, you can have. Okay, chat. Correct me if I'm wrong, but I think in this case, you can have a witness who you have not subpoenaed. If the witness volunteers to show up or will willingly show up, I don't think you have to have a subpoena.
I mean,
it's just extra insurance.
I don't want to say the wrong thing, so
I don't either. That's why I'm asking this question. But my understanding is, you don't even need a subpoena. Terry Bowe could say, "I just want to be there," and show up.
I mean, I would totally watch the shit show for free. You know what I mean? You don't have to force me.
Yeah, Patrick says you don't need a subpoena to go testify in a case.
Oh, hey, Patrick. What's going on? I miss Patrick.
So so this motion eliminates, again, this falls flat to me.
I mean, the whole thing falls kind of flat.
It's not convincing me very well. She's not doing a good job of convincing me.
Indictment and ongoing criminal investigation are not admissible evidence. Ms. Bowe's proposed testimony concerns an ongoing Arizona criminal case that remains at the indictment stage. An indictment is not evidence of guilt. It is merely an accusation. I mean, did they say that she was absolutely going to say that she's guilty? I mean,
no.
I don't think that's the case. Improper opinion on credibility. Ms. Bowe's stated purpose to explain the investigative findings showing a deliberate pattern of deception relevant to credibility constitutes an impermissible expert or lay opinion on a party's veracity. I don't know about that. I really just don't know. Let's see. We're gonna keep going.
I mean, it really depends on how much of the credibility they want to talk about or the pattern of behavior that they want to allow in the case. Sure. Because really, that's what the criminal indictment is pointing to, is the pattern of behavior here.
Yeah. So long as Laura was given notice, he will appear. That's all that you need. Yeah,
So it really depends on how broadly the judge wants to look at everything here, I think, or can, based on their interpretation of the applicable laws. She's making an argument that everything here should be really narrow.
Yeah.
Which is typically how these arguments go. If you go back to the Owens v. Eckerd case, you could see areas where Gingras was really trying to narrow the scope of things because that was better for him. And, Clayton or Woodnick were trying to widen things on certain issues because that was better for them. And that's happening again here. And that's just typical of court cases, I think.
Yeah. Okay.
You figure out if it's better for your case to have a wider scope of inquiry or a narrower scope of inquiry.
Okay. This is Clayton's. I told you this was going to say the same thing. Hang on. No Arizona ruling has ever found that petitioner fabricated or falsified abuse.
Yeah, it did. Well, this is just wrong.
Okay.
Oh, well, wait.
This is abuse allegations, I guess.
No. Wait. Look at it, how it's different. It says no ruling has ever found the petitioner fabricated or falsified abuse allegations.
Yeah.
And no court has deemed her fear unreasonable. So she does admit that she faked evidence and faked a pregnancy. In this, if you compare and contrast this paragraph with the other paragraph.
Sure.
So this is interesting. And then she says no court has deemed her fear unreasonable. I mean, courts don't make rulings on reasonable fear. I mean, I don't know.
There's not like a personality profile that comes with it. I mean, I don't know what you're getting at here.
Technically, that could be false because Mata did say that she wanted to overturn the OOP that Owens had against Eckerd, but it wasn't procedurally the right place. Right. So procedurally, she couldn't overturn it and prove that point. But in her ruling, she effectively made that opinion and published that opinion. So the statement that Laura put above is still kind of wrong. Mm-hmm. Even though she tried to change the criteria to make it right.
Patrick, the one that appears sometimes. Yeah, Patrick is here sometimes. It's just during the day. I figure he's doing his, work or whatever. So
we sent out a hat signal.
Let me run through these real quick. Fake Laura Owens, thank you for the $5 because my blood test in August is an emergency now. Thanks, mommy.
Right.
Can you help me with that one? I don't understand it. Don't answer that. Fake Laura Owens, thank you for the $5. She cures me with sage burning and purple holistic crystals. Also, Himalayan pink rock salt helps so much. Are we talking about Dr. Green?
Maybe.
Okay. All right. That's very specific.
Or the mom.
Grandma Ray, thank you for too. How the judge know Dr. Green is not an MD. I mean, I'm assuming Dr. Green would sign, whatever letter she's writing that she's like a PMHNP or whatever it is.
You would presumably have a signature block in this letter that we don't have.
Yeah. I mean, it would say DNP. It would at least say DNP, which is Doctor Nursing Practice, not MD. Wendy, thank you for the $5. Could Omar, for a dismissal of the order for no showing? I don't fucking know how that works. I'm sorry. I wish I could tell you. Pat signal. That's cute, guys.
That's what I said.
Oh, that was, again, ADHD is on today.
It's fine. I'm just here for the chat.
Okay. Well, fair enough. I understand.
I'm just one of the peons. I'm not like His Majesty or anything like that.
No identical patterns and no relevance to this proceeding. Respondent's assertion that Mr. Eckerd's case shows identical behavioral patterns is factually and legally baseless. Petitioner has filed no paternity or protective order case against respondent Marraccini. Okay. What? I mean, it's not called a protective order. I guess it's called a DVRO, but really? That's what you're going with?
So petitioner's filed no paternity or protective order case against respondent Marraccini. I mean, yeah, does she have these DVROs against Marraccini?
I guess she's going with semantics. Is that what we're bringing up?
What's the difference between what she had against Marraccini and a protective order? I don't understand the difference.
Good question.
So that I don't understand that. Paternity is kind of irrelevant because when people are talking about identical behavioral patterns, they're not saying identical court classification filing patterns. Okay, they're saying behavioral patterns. What she's doing is she's trying to nitpick a specific detail that is irrelevant to the original argument.
Rachel says it's ChatGPT all the way. You know what? I hate ChatGPT, but I will say a couple of times when I had to write something that was like really important and I knew I was too emotionally charged, I'll write the whole thing and I'll put it in ChatGPT and I was like, can you make this sound less angry? It does give a lot of bullet points.
I don't know.
So
I feel like there'd be more EM dashes, but maybe she takes them out.
Yeah, I mean, that's what I did. So
that's fair. That's what I would do.
Yeah. All right, let's see. I mean, we know about this. I'm not gonna fuck with this. Plus, I have limited time left.
Things are happening.
Didn't we already go through Greg? Are you that concerned about Greg? We got him on here twice. Hang on. Did ChatGPT malfunction? It seems to hallucinate things. So I don't know, man.
We've cut and paste errors here.
Yeah, she definitely did.
So witness 5 is Greg, and then what?
No, that was 3, right?
That was 5 again down below.
Yeah, so he was 3.
Section 3. Oh, he's still number 5, right?
Yeah, I guess so.
Oh boy.
No, Clayton's 5. Hang on.
He's 5?
Yeah, Greg is 3
7.
and 6. 3 and 6.
This is 7. Oh, you're looking at I'm looking at witness numbers.
I'm looking at this sections. Sorry.
No. Use the witness numbers. But anyway.
Okay, well, he's on here twice.
Is there different stuff in here though, or is it copy paste?
Hold on. Trying to skim. I don't want to read all this again.
This is trouble. We need an editor.
Yo. Petitioner's 3 uncontested protective orders, each entered on findings of reasonable cause to believe Mr. Gillespie may commit domestic violence. I don't know if that's exactly the truth, but okay. Directly contradict the assertion of false abuse allegations. Why is this not up there?
I mean, the problem is the argument here is that she has to prove some DV between 2020 and 2025. And she does this circular argument thing where she says, I already had this other order, or I'm trying to renew something. Therefore, it should just be valid because of that, which is very circular as opposed to, any sort of just point at the actual concrete evidence.
Sorry,
she's always using the court docket as some sort of like statement of fact. It's a statement of maybe it's a ruling, or there's a finding, or there's an opinion, and you can argue that there was an opinion.
Is this not the place to make factual allegations of someone being a demon or a cult leader? I don't know. I'm a little confused about the purpose of the courts these days. So, just saying.
It's a wild time.
Yeah.
No, the purpose of the court is to keep compact disc players in business, I think.
Okay, moving on.
Right.
No, actually, somebody uploaded that to a website this morning, so I did not actually have to buy a CD player.
I know.
But, thank you, Clark.
Call back.
Yeah. Call back to 5 hours ago. The first thing I did this morning was like, somebody's got to have this.
All my jokes are inside baseball.
Yeah, I don't like baseball. Just saying, if anyone missed that, it looks so bad for Blake. I'm just saying.
Yeah, it does.
So bad. I love it. I'm a little petty these days. Yeah, I'm gonna skim. Like I said, I've read enough about Greg. Sorry, Greg. So this was the friend that she, wrote that like crazy bullshit about. I don't feel like, again, I don't feel like the court should be used to, like paint someone as a demon who's just like a random, like third party or whatever.
Wait, was this not her witness?
Well, Mike is listing her as a witness as well as Laura. So out of respect for that person who, it's unlikely that anything Laura says is true. I'm going to skip this part, okay?
I get it, but why is she filing a motion in limine to exclude her own witness?
I don't know. She's an idiot, but I just wanted to put that.
What kind of clown show is this, Lauren?
The kind that I'm redacting, because I don't think that anybody should be put through that if they really like have nothing to do with this. So.
I mean, I agree with you, but it seems like very strange procedural behavior to exclude your own witness.
Well, I'm not saying she's not a fucking moron. I mean, just that I'm not going to pay attention to it. So, if I wanted to read something that made my skin crawl, I would just go to her lawyer's blog.
Sure.
All right. Exclude irrelevant and improper exhibits. I don't know what else is on here, but I think it looked like pretty much a lot of everything. Under advisement ruling from the Superior Court of Arizona issued by Judge Julie Mata. Let's see. Out-of-state minute entry and unrelated litigation. Contains no findings regarding petitioner's relationship with respondent Marraccini or her present apprehension of abuse. So isn't she bringing in, though, this whole case when she's saying that the basis for her renewal request is Mike being at that trial. I mean, does that not matter? I don't know.
Well, as it relates to whether or not the subpoena for Mike to be there was valid or not, if there is something that, if Greg Woodnick is a witness, if a minute entry or a ruling that Judge Mata filed has anything to do with that, then I think it would be very directly related to her petitioner's case. Now, if you start going off into the weeds, maybe there's an argument that it's irrelevant to the current case. And this is where we get to that, are we widening the scope or narrowing the scope, in my opinion?
Sorry, one second.
But I think there's plenty of stuff that was there in the Owens v. Eckerd case that the judge wrote, or that, Greg Woodnick could testify to, that is directly about Marraccini's involvement in that case.
Sure.
And if the judge is interested in the pattern of behavior, then you've got, how long do you have, Your Honor?
2 days.
Yeah.
There we go. Gotta get back to work in a few minutes. So, criminal indictment from the Superior Court of Arizona filed on May 1st. Okay.
Does someone get rid of the troll?
Which troll?
In chat.
Hang on. Oh no. Oh no. Sorry. Somebody hates my giggling. They come back with a new username like every 4 minutes. Hang on.
Yeah.
Oh, thanks, Patrick. You can just you don't have to delete it. You can just ban that person. I don't give a fuck. No, I'll do it. Here. It gives me some pleasure. Bye. You should really find another hobby, dude. That actually just doesn't bother me at all. It's annoying for other people, so I'll get rid of it, but I actually don't give a fuck. So, all right.
They seem to like me.
They do like you. They're a big fan of Bruce. They only come around when Bruce is here.
What did I do?
Yeah, I don't know, but apparently I laugh too much, and it stops you from talking, which I agree, but I'm not going to stop doing that because, I kind of do what I want, so you should probably leave.
I think if the biggest fans are my biggest fans are the trolls, I'm doing something wrong. I don't know.
I think it's kind of funny. I don't know. You've had your fair share of trolls too, so it's nice that somebody's on the Bruce fan club here.
It's true. There's been a couple.
I've seen you deal with some real assholes.
There's been a couple trollmakers out there in the world.
All right, we're almost done here. Okay, so she has the correspondence from Dr. Chan and Dr. Yi, which are almost certainly fake. She's saying that's not, relevant. It's not part of the prior court record.
She's really worried about that one.
Yeah. San Francisco police reports. That's the one that Mike filed. Or yeah, he called the police before she ever filed a DVRO request. So, relating to third-party investigation, not linked to respondent, and not part of the domestic violence record. Well, then what the fuck is this?
Maybe this is a different case number.
I thought we were talking about the initial police report because it is a San Francisco police report. So what are we talking about here?
Wow, this is interesting.
That's a little weird.
This could be, if this is not related, if this isn't Mike doing this report.
Well, unless it's his sister.
Then it could be his sister who filed it, or it could be completely related to something else.
Maybe. I mean, I wouldn't be surprised if she had some other, other people calling the cops. So, all right, let's see. Image of Laura with redness around her face, particularly her right eye. Well, we know about that one. So that's pretty damning at least in the eyes of the public watching her TED Talk. It's pretty bad. Undated and unauthenticated photograph offered without foundation. I know that what that means without foundation, but I like to imagine that she's saying without foundation. You know what I mean? Because she's a little pain. No, okay. Petitioner's medical appearance years prior has no probative value on current fears and risk undue prejudice. Well, then what does Ariana Huffington have to do with current fear and risk of undue prejudice? Fuck you. Okay. I'm not talking about that again. Petition for protection against Clayton, whatever. Subpoena issued by Superior Court of Arizona to Mike Marraccini. This is not going to go how she thinks it's going to go. She's had the worst legal advice in the world. Good luck with that. Yeah, let's see.
I mean, she's trying.
Certainly, but that's never a good thing, you know. Civil complaint against Greg Gillespie. I think she means 2021 here. Petitions for order of protection against Greg Gillespie filed November 12th, 2021 and December 6th. Okay. Positive pregnancy test by Laura, August 19th, 2016. Unauthenticated photograph or record predating issuance of DVRO by 2 years. Irrelevant to current fear. I mean, again, it kind of goes to like she's faking a whole bunch of stuff, but okay. She wants these text messages taken out, obviously. Texts claiming that the abortion pills did not work. Which time? She'd said that like 40 times. All the messages predate the 2018 restraining order by several years, were never part of the record, and concern matters wholly unrelated. Okay. Well, again, if you want to talk about things that are wholly unrelated, we got to look at your entire witness list. Facebook post of Laura Owens at KGO celebration. That's the one where she's like out partying and drinking when she says she was in the hospital with a potential miscarriage.
Yeah.
Yeah. Okay.
Introduction would only serve to harass? In what way? Trying to prove perjury is harassment?
Yeah.
Come on.
Jesus Christ. Okay. Deposition of Laura Owens in the Eckerd paternity case regarding Dr. Chan and having an ovary removed.
Mm-hmm.
All right. Equestrian rider reports. Petition for order of protection by Greg Gillespie. That was the one that she was never served with, but he did, file it. Let's see. Text message from Laura Owens to Michael Marraccini stating she loves and trusts you. A single text from 9 years ago predating issuance of the restraining order. But you're trying to bring Napkin Lady back in here. Like, what? Try to be a little more consistent.
I think when we're talking about Mike, Laura is remote and irrelevant.
Okay. Fair enough. Yeah. Oh, no. I can't read that one.
Mm-hmm.
Bruce.
Yeah.
I'll have an immature little fallout. You have to read that one.
No, I don't want to.
You have to read that one. Just do me this.
Exhibit 123, text message from Laura Owens stating, "Love you, I'm horny, baby. I wish we could get dinner. Ooh la la." May 19th, 2017. Personal message from 2017, long before issuance of DVRO, unrelated to current apprehension. She has apprehension? Wait, I thought she had fear. Now she has apprehension. Why is one and one's the other? What do you think, Lauren?
I'm trying not to.
Maybe she's just apprehensive about admitting she was horny.
It's horrifying. All right. Anyways.
Here we
are. Email from Laura's attorney, David Gingras, to respondent, dated May 8th. That was okay. I know what that was. Evidence that petitioner sought direct communication. She did. So, okay. Email to media tip line regarding Clayton Eckerd paternity update. Media correspondent unrelated to Marraccini or current fear. All right.
Media tip line.
Yeah. I mean, she did a whole thing. Yeah. State's notice of disclosure and request for disclosure. Laura, you're boring me. Text messages by Laura regarding inpatient psychiatric therapy. So she said that she was getting it. Her text messages suggest otherwise for the fact that she's sending text messages. They don't let you do that when you're on a psych hold. And then she later says that, I never said that. So.
Wait, we're supposed to go back to 124.
Do we have to?
Yeah, real quick.
I'm afraid of which one that was. Oh, no. Okay, that's not.
Email from Laura's attorney, Gingras, to respondent. Okay.
Yeah, that was the email where he's saying that, Laura wants to talk to Mike directly.
Now scroll down. Respondent characterizes this email as evidence that petitioner sought direct communication in violation of the current restraining order. That claim is legally and factually incorrect. The restraining order protects petitioner and restrains respondent. It imposes no reciprocal prohibition on petitioner. Even if petitioner had initiated contact, such contact could not constitute a violation of her own protective order. Is anybody claiming it's a violation? I think what they're claiming is that it's sort of this manipulative behavior, right? This threatening behavior.
You're not that afraid of the guy if you want to talk to him alone. You know what I mean?
Exactly. Nobody's arguing she violated something.
Yeah.
In any event, the email was authored solely by petitioner's counsel, David Gingras, who has confirmed that he misunderstood petitioner's instructions.
Yeah.
Oh, boy.
Okay, sure.
David Gingras fucking up yet again. Are
Yeah,
you
David is
surprised,
just a
Lauren?
misunderstood
Okay,
guy.
and sent the message without her consent. So he was her attorney and sent attorney witness communication without his client's consent? Isn't that a potential bar violation? Oh dear, this is trouble.
Mm-hmm.
Oh my goodness.
All right, we're
Well,
almost
she's
at the
certainly
end here.
throwing
I know.
Gingras under the bus here.
I mean, somebody should, frankly. Not literally, David. Okay. Declaration of Laura Owens, March 29, 2018. Okay, already contained in 2018 record. So, what's your point? Findings after trial by Judge Mata. Out-of-state ruling from unrelated litigation. Okay, whatever.
Exclude is cumulative.
Petition to court order paternity filed by Laura Owens on August 1st. I love that.
No nexus to respondent. She's really rolling out the 50-cent words.
Yeah. Well, it's all she can afford these days. It's 50 cents. Hope they include that in the bankruptcy filings.
Are we done? Why is my face so big, Lauren?
I don't know. My face is super red, though. Okay. Anne, I would like you to work on your spelling there. Lauren did accuse Eckhart of rape. Eckhart did not rape Lauren. I don't really know what you're getting at there, but yeah, okay.
No. She's talking about how this
I know.
goes to impugn the credibility of Miss Owens here.
No, I was just being a dick. All right. I got to go, guys.
Fair take. Okay.
Yeah. All right. Thanks, Bruce. I will be around later. I don't know. I gotta go. I gotta do a couple more hours, and I gotta go find Steve. So,
all right. Best of luck to you, Lauren, for tomorrow and everything. That
I don't need it. She's not gonna show up, and also all I would have to do is sit there. So,
I think she will show up over Zoom.
I still don't. Okay, you and I are never gonna agree on this. We're just gonna.
You think she's not even gonna show up on Zoom?
I do not think she's going to show up on Zoom. No.
Really?
No, I do not think that she will represent herself.
I think she can show up. She will show up on Zoom, but that's all I got.
It's fine. We can fight about it later.
No, it's fine.
Preferably with fists.
I'm not trying to convince you. I'm just telling you that's where I am.
No, I know, dude. I know it's okay. We'll see though. I have low expectations. I'm perfectly happy to just.
If you keep your expectations low, you'll always be pleasantly surprised.
Yeah, I usually think that, but sometimes I just get a whole heap of nothing. So
instead of disappointed.
Well,
I'm disappointed by these filings. They did not convince me. I did not find them high quality. And we carry on.
Yeah. When is Bruce going live? I don't know, Bruce. You should tell him.
Live? I don't know. I have to go live?
Apparently. I support that.
Live from where? The cheese shack?
You no longer have any choice in the matter. You're supposed to go to your wood panel room or whatever.
Oh, wood panel room. Yeah, I'll make some videos from my ensconced in wood paneling.
Yeah, do that. All right, I gotta go because I really gotta go. So, all right, bye.
Cheers.